Are vouchers constitutional? Now, it was not my idea to give you a podcast about the law and constitutionality of said laws, but I've been requested by a number of districts to kind of explore this. I guess they're talking to their lawyers, and the state associations are trying to figure out whether or not they want to combat vouchers and school choice constitutionality, and whether or not they want to go down that road. And so I'm going to put on my law hat, and I'm going to get back to good old, I think it was in our first year of law school, we learned how to brief legal cases. And briefing legal cases is like you come up with the facts and the rulings, and then you try to surmise, guess what impact it will have on other similarly situated cases. So we're going to, look, I'm going to put on my glasses, and I briefed some cases like I feel like a first year law student again. But we are going to talk about vouchers. But before we get into whether or not you're for or against vouchers, we're going to have to establish a baseline. And the baseline is really, what does the federal law actually guarantee for K-12 education? What is required by our government? What is mandatory, and what we're allowed to do and what we have to do, what is mandatory under the federal laws. And then every state obviously has their own constitutions too, which we'll have to kind of explore that a little bit too. So, but this baseline is really about setting the rules of the game for every state and every district, and really, like every family, right? So we're going to talk about the U.S. Supreme Court cases and what those facts are and what the court held and what those rulings are. But a quick little primer about how the law works, if you're not familiar, is we have, I know that you know this part, but just bear with me for a second. We have states and we have the federal government, and every state has their own state laws, and then we have federal laws. Now, the federal law, the law of the land, so to speak, trumps all state laws. Okay, so states can have additional rules and additional policies, but they cannot do less than what the federal government mandates that we all comply with. So yes, you have a state Supreme Court and a federal Supreme Court, but the federal Supreme Court is in charge of the state Supreme Courts. But if the federal court, the federal law has no law, then you look at what the state laws are. And that's kind of a general way to think about it. So when you hear a Supreme Court case, is it a state Supreme Court case, which only applies to that state? Or is it a federal Supreme Court case, which applies to all the states, right? And we're not going to get into constitutional law. I don't even know if I'm qualified to completely do that, but I did have an outstanding constitutional law professor, Professor Swartz, in law school. So understanding we're talking about federal law, everyone has to comply with it, and then you have your individual state laws, which just those state schools. So you have to kind of know both. You have to know where the federal one and the state one. So we're gonna dig into the federal one first. All right. So let's start off with the federal baseline about what does the U.S. Constitution do and does not guarantee. All right. First thing you have to know, there is no federal constitutional right to education. Sounds weird, doesn't it? It sounds a little weird to me. I mean, I knew it was true because I knew what the law was, but education is not a right? So that means the federal government doesn't have to provide it, is why that matters, right? So without a fundamental right in the U.S. Constitution, the biggest fights over funding, adequacy, voucher programs often move to those state constitution and those individual states and how that works, right? But we do have federal civil rights statutes, and they're attached to federal dollars also. So you still have to know what the federal law says and how that's going to impact, and then you have to turn to the individual states. So we're going to start off with the federal, of course, like I said. So laws like federal equal protection, civil rights laws really provide like guardrails that can be excluded on whether students truly have access to learning. Now, I'm going to break this down a little bit by giving you some interesting case law, all right? So here's kind of the chronological order of big, impactful cases on the federal education system. And the first one is going to be no surprise, the 1954 case of Brown versus Board of Education, right? And so this was really talking about, well, segregation, right? And the facts, pretty simple, were African-American children, black children were denied admission to white public schools under the current segregation laws of the United States, which had not been around for hundreds of years, but had been around long enough to have some really devastating impacts, right? So what was the holding? Okay, so I think we don't have to dig into this case too much. Most people know this, that, maybe the white schools were better and the black children wanted to go to those schools to receive a different kind of education, a better education potentially, or at least the same education, right? At least that we wanted the same education for all our kids. And so what did the Supreme Court, this went all the way up to the U.S. Federal Supreme Court. So when they make a ruling, every state has got to follow it. And it held that I wrote this down. It held that separate educational facilities are inherently unequal. So they're not the same. So racial segregation in public schools violates the Equal Protection Clause of the U.S. Constitution. So we do have an Equal Protection Clause, right? And so this matters because any policy, voucher or otherwise, by the way, that results in segregation or denial of equal educational opportunities is measured against this Brown's decision, which are those core equitable principles. Now, it was mainly dealing with race, all right? But the Equal Protection Clause can kind of go beyond that to religion and some other things. But we're gonna kind of keep it tight right now. Okay, so a year later, Brown versus Board of Education, like we call it Brown 2, right? And 55 came out and said, after Brown 1, the court also addressed how to implement desegregation, right? We should have never had segregation, but now how to get rid of it. And the federal courts must supervise desegregation with all deliberate speed, which means we're going to uncork segregation. We're going to make everybody be able to go to whatever schools. And you guys remember all the crazy news. I'm too young. I was not alive in the 50s. Okay. But I've seen videos, right? So we get rid of segregation. So that means everybody should be allowed to have equal access to public education, even though public education is not a right under the U.S. Constitution. So you can just get rid of all education under the federal statute. Isn't that weird? Well, the federal government, by the way, doesn't actually provide education. We have a Department of Education, which came out and implemented in 1979, actually started, in 80, 81. But it doesn't actually educate any children. It provides a funding mechanism. It provides science, data, analysis, grants, things like that. The bulk of federal funding doesn't even come through the Department of Education. It's mainly in food and dollars, which doesn't come through the Department of Education. It comes through other federal programs, right? So no mandatory education, but if you're going to do it, you can't segment out people based on race. So just kind of keep that in mind. All right. Let's fast forward 9 years. So in 1964, another big federal court came down, which was Griffin versus the County School Board of Prince Edward County. The facts of this one were that a county shut down public schools and offered tuition grants. Now we call those vouchers. Offered tuition grants for private segregation academies to avoid integration. So what happened after the 50s, there were white flight. It was real in the 50s, early 60s, and people said, "Well, wait a minute, I'm going to get around the segregation. So we're not even going to offer free public schools. We're just not going to have for public education. So we're just going to give vouchers to people and use them however they want to." Well, it kind of feels like it's missing the spirit of the law, right? The spirit of the law was, if a state is going to provide public education, they're going to use tax dollars, their state tax dollars to do it. You can't discriminate. And then they try to find a workaround. Now, there's a real interesting thing about the law. Everybody loves in the law to argue about little exceptions or little tricks. Man, most judges are not going to let you get away with that garbage. They're going to realize that you're trying to do a sneaky little wicket, that you're trying to be clever, and they're going to overrule that, and they're not going to allow it, okay? So anytime you get somebody trying to use the law as a sword instead of a shield, the law is supposed to be there to shield you against bad results and to protect your rights. But people are trying to be clever. Man, the law does not like you to try to be clever, and the law does not turn a blind eye to that, aha, you got us. Oh, wow. So Prince Edward County, you sure fooled us, right? You got rid of public education and just gave everyone grants, aka vouchers. They called them grants back in the 60s, right? But they were vouchers, right? And so what does the court do? Like, what does the court do when you're trying to it's like a parent and a child. The child's trying to, you said I could stay out till 11, but you didn't say 11 a.m. or 11 p.m. and I'm home before 11 a.m. You're still in trouble, man. Like, nice try, right? Okay. So the court in Griffin versus County School Board of Prince Edward County said that closing public schools to circumvent desegregation violates the equal protection. So no, nice try, way to try to be clever, but you don't get to just close all your public schools and still provide money for public education to get around the segregation. Nice try, schmucks. And that's really what I see so many times. People, even like a DUI or a criminal investigation, they always try to little cons like this. I don't know if you've heard of this sovereign citizen garbage. Somebody out there put out there, well, if you say, look, I know I'm digressing a little bit for story time, but there's this whole movement out there of people that aren't too smart that think that they're not citizens, they're sovereign citizens, so they don't have to obey the laws of the land. And it was actually my constitutional law professor, Professor Swartz, who said, look, I get that there's administrative laws and there are federal laws and constitutional laws, but what's the difference? People try to argue, but the whole point was, you go to jail, you go to jail. Right? Like, it doesn't matter if it was administrative law or rule or federal law or state law. If you're in jail, it probably doesn't matter. The outcome is you're locked up and you ain't got no freedom. And so, the county school board of Prince Edward County tried to, be clever and say, we're just going to use our taxpayer money, but you can then segregate and discriminate. But it's not our fault because we don't actually hire the school board anymore. Nice try. No dice. The law did the right thing. And it was the spirit of the Equal Protection Clause that really mattered here, right? And so the federal court slammed them and said governments cannot use funding schemes. They called it a scheme, like a con, right? To avoid constitutional equity matters. So nice try. No dice. All right. Now let's get to another really pivotal case about school choice and vouchers and things like that. And this was, it's another 9 years. Isn't that funny? 55 to 64 to 73. So now we're in 1973. This was the year after I was born. So little Brian Stevens was on the planet when this court case came out. San Antonio Independent School District versus Rodriguez, if you want to look this up. Okay, so here are the facts. Texas at the time, so this is a Texas case, relied very heavily on local property taxes to fund schools, which is true right now of almost every public school in the nation. Most public schools are funded primarily through property taxes. You can get some grants and some other programs and things like that. Maybe some states have income tax and they get an additional funding from the state, but primarily it's local property tax, right? And obviously property taxes are different in almost every single county and every single city across the nation. I mean, there's some things that are in alignment, but if I live in Memphis, Tennessee, and our property taxes are different than if you live in Shelby County, which is the county that Memphis is in. Or if you go right over the border to Mississippi, different property taxes, and their public schools are funded through these property taxes, but the different cities and governments collect taxes differently. Okay, so this is how it was in 73. So Texas relied really heavily on these local property taxes, just like now. And this created really large spending gaps between rich districts and poor districts. So I went to military school in Alabama, and I think was it Belmead? I can't remember the area, but there was Birmingham, Alabama, and they have a very rich neighborhood. And they had public schools were like gold plated, and this is before computers, but everybody had, beautiful brand new books and all these things. In the public school I went to before that, you had the torn books because they didn't have as much money. That seemed unfair. All right. And so the people in Rodriguez sued because they thought that was unfair, that all schools should be paid equally in the same amount, right? That was their theory. So the parents argued that you have rich districts and poor districts, and this violated the Equal Protection Clause of the United States Constitution, because education is fundamental and poor students are at-risk class. Okay, so remember, God, I hope this isn't nerding up with you too much, but if you love constitutional law, this is your show right now. Is in Brown versus Board of Education, we said, look, you can't segment out blacks and whites or Native Americans and black people and Hispanics and black, or whatever the different races are, they all got to be treated equally. Well, this group said that poor and rich people should be treated the same because poor children should be a protected class. That's what kind of that suspect class means. They don't mean like you're a suspect like in criminal law. They mean like protected, like you're at risk, right? Well, remember, there is no guarantee in the federal courts that education is a fundamental guaranteed right. And that's where we had to start with that. Because if it was a fundamental right, it's a fundamental right and everyone's got to be treated equally across the board, across the table. But it's not a fundamental right. It's not a right at all. So if you're going to do it, you can't discriminate, at least according to race. That's what we know as of 73. But they said, now we don't want you to even discriminate based on wealth, which is a different type of category altogether. And I hope you see that. If you have questions, send me emails about this. Or call a constitutional lawyer that probably knows more than me. All right. So now in San Antonio versus Rodriguez, the holding was that education is not a fundamental right under the U.S. Constitution. Duh. But they restated that. And they go, wealth is not a suspect class, a protected class. Wealth, whether or not you have wealth or not wealth, is not a protected class. That the funding system only needed a rational basis. I'll get to what that means in a second. Only needed a rational basis, which the court found in the state's legitimate interest in local control, letting communities set priorities and raise taxes accordingly, right? So a rational basis is a much lower standard, okay? So, I didn't really want to dig too much. Let me kind of give you the synopsis. So let me give you the example under criminal law. So if you want to be convicted, not if you want to be, if somebody needs to be convicted of murder or a felony, it has to be beyond a reasonable doubt. Very, very high. Like no reasonable doubt. And if there's any reasonable doubt, they're off. The next standard down is clear and convincing, right? Which is like more, I'm 50% plus. I'm 70% sure. The percentages are a little rough, but I'm pretty sure, but I have some doubt, but I can go and convict them. And then you have by preponderance of evidence. That's just over 50%. So it's more likely they did it than they didn't do it. So a lower threshold, not for felonies, right? And so we don't have this standard, which is I'm trying to think about this. Maybe they did it, right? So we have these clear and convincing preponderance and reasonable doubt, right? Well, they said you need a rational basis. So is there any rational, like reasonable, right? So is there any rational way for me to explain why one school district gets more property taxes to pay for education than another one? And yeah, there's a lot of reasons, right? It could be, well, you choose to live in an area that makes more money. You choose to pay more in taxes and you want more to go to education. And that's your decision as a group. So think about it this way. Let's assume you live in a state, in a city, and the city has a tax referendum. And everybody votes, yes, we will approve a 5-cent sales tax or 5% property tax increase to help fund public education. And that community decides to do that. Or I vote in city council people or county commissioners that vote to fund public education higher than the county next to me. Well, then I can choose to move to that county or I could choose not to move to that county because I either want to be taxed more and have more go to education or I want to be taxed less and have go less to education. Those are decisions that people can make. And it seems like a rational basis. If I want to live in an area that has a higher tax rate and have more to education, well, then we should be able to fund our schools more if that's what we as a community want to do. So that's about local autonomy, right? And local control. And that's where San Antonio versus Rodriguez was really digging at, which is there's a legitimate interest to different counties and different governments and different communities wanting to give more or less money to their school districts. Right? And think about it this way. In some cities, the rate of poverty is really high. And there's less educational opportunities for all those students because maybe they are growing up with one parent in the household, or maybe they're being raised with no parents, and maybe those people don't have a lot of money for tutoring. They don't have a lot of money for trips and books and going to museums and being read stories and all that stuff. So maybe that city wants to fund their education more to give all those kids a little bit more help to get them to become a great adult. Right. And maybe other school districts are like, we don't need to put that much in it because our families have money and it's okay. But I know sometimes you see the opposite, right? But I get that. But that was kind of the idea, is that we should be able to fund the education based on what we want out of our children when they become grown adults. Okay, so that was the rational basis. So this lets communities set priorities and raises taxes according to what they want. So the why this matters is that under federal law, inequities from local property tax funding can survive. You can fund schools differently, and I think we all know that because this was 52 years ago now, right? So we know this, but that's kind of, you need to kind of know the history in order to determine how vouchers are going to work in your state. So it's important to get this historical lesson, so to speak, right? All right, so this is why funding equalization rights often hinge on state constitutions, not the federal constitutions. You can't use an equal protection clause. You have to look at the state constitution and decide whether or not every county's got to be the same. So forget about the federal constitution if you want equal pricing. All right. So a year later, Law versus Nichols came out. This was in San Francisco, right? Yeah, San Francisco. And San Francisco taught only in English. Now, in 74, we didn't have a national language. There was no, by law, English was our national language. I mean, most people spoke it, but it was not our national language. We didn't have it in 74. Funny, right? And so San Francisco, I mean, not funny that it should be English. It's just funny that people assume that English was a national language. It just wasn't. But in San Francisco, thousands of families were Chinese speaking, and the students received no language support, right? And you think about that with the large Hispanic populations now. And so do you have to teach in extra languages, right? And the holding was that even if facilities and teachers are the same, students who cannot understand instruction are deemed meaningful access to free education. That means they're not getting meaningful access to education. And that violates Title VI, which is discrimination in federally funded programs. So schools must begin to take, this was in 74, affirmative steps so that English learners, so that the learners benefit, right? So that all different languages can learn equally. And so it means that access must be real. It can't just be theoretical. And public districts bear duties to ensure that language access is equal. So private schools now that participate in voucher programs may have lighter or different obligations unless states write those duties into the voucher program. Interesting, right? So right now we know that if you're a public school, your websites have got to be, a very melting pot of languages, right? You want to give a lot of access to a lot of different languages, from Spanish to Mandarin to English, et cetera. Do schools that get vouchers have to do that? I don't know. Unless it's specific or rented into the voucher rule, maybe not. And so this begins to start looking like maybe we are segmenting out the populations again, based on different groups, like whether or not you speak English or don't speak English. Or heck, it could be we have a voucher program, private school that only speaks Mandarin. And if you don't speak Mandarin, you can't be a part of that. That's the same thing, right? Okay. So now we jump to 82, and this is where Texas sought to deny free public education or charge tuition, but they wanted to charge tuition to undocumented children. Now, the theme about this was, well, their parents don't pay property taxes. Their parents aren't paying sales tax necessarily. They're not paying, they don't do the IRS forms that we're all supposed to do every year, pay, Uncle Sam all this money and stuff. So in Plyler versus Doe, which was in 82, the holding was that this violated equal protection because, well, while undocumented status isn't a suspect class and education isn't a fundamental right, okay, the state lacked a substantial justification for imposing a lifelong hardship on children that weren't responsible for their status. Now, it's kind of like what I was talking about earlier. The courts are going to try inevitably to do the right thing. And here, do we want, it doesn't matter. Like, grow up. It doesn't matter where you are on documented or undocumented students and whether or not you want them all gone or you want them all to stay or you want super easy access to everyone that's from another country to be admitted citizenship here. It is completely irrelevant. I do not care where you stand on that argument, and you shouldn't care either for about another 5 minutes. Okay? If they're here, you don't get to snap your fingers and wish for the world to change. This is the world we live on. It is 2025. We have undocumented kids in America, right in the United States right now. And I don't care how much ICE and immigration reforms you change. Most of them are not leaving. Most of them will be here and a part of this country until they pass away or until you pass away. Okay. They're going to be here. So don't care. I hear you, but that's not fair and that's not right. I don't care necessarily what's always fair and right, because remember what Socrates taught us. Control your controllables. And you don't have you can try to work on getting kids deported all you want. I'm not advocating for that, but it is irrelevant again, because they're here and you either want them to become a productive member of our society and our culture, or you're just ignorant. Because it's going to be one or the other. They're either a productive member or they're a drain on society. Well, I don't like either of those options. I'd like them to go, Brian. Well, tough. I didn't make the rules. I didn't allow people. I don't know if you want a wall or don't want a wall. I don't care, right? I mean, I do. I have opinions about that, but this is not the time or place. Right now, we're talking about the kids. Think about the children for a minute that are going to become adults one day. Do you want them working jobs and helping society and paying taxes and knowing that the earth is not flat, having an education, knowing how to do math, or do you want them to be criminals? Because if you have a person and they receive no education, how are they going to survive? Oh, wait. Get it? I don't want to get sued by Jeopardy. I'm going to stop. If they don't get education, they're a drain to society. If you disagree with that premise, please call me. Let me know. I would love to hear the argument. I will have you on the podcast. I will promote it. I would love for somebody to explain to me that education is not important for all members of society. Let's just say it if you believe that. And we can have a vigorous discussion and you can attempt to explain to me that I'm wrong. I would love to hear this argument because it would make my life a lot easier. If out of the 50 million children that are K-12 age right now, if it's okay with 10 million of them just being idiots their whole life. I don't mean like disabled in any way. What I mean is like no wisdom because they have no education, right? They are the same person at 8 as they are at 50. They just have learned nothing because we chose not to educate them. That's what I'm talking about here. Okay. So the court said that these undocumented kids, they're going to be here. So we might as well educate them. Makes a lot of sense to me, right? So they said that public school doors must remain open to all children, and voucher designs that facilitate screening or exclusion raise equal protection concerns and policy questions. So we do know this from Plyler versus Doe. I mean, it hasn't been litigated, but we're pretty sure about this, is that if there are voucher programs, undocumented kids get access to them. Let me say that again. If you have a voucher program, undocumented children get access to them. Okay, that's the equal protection clause. I don't care what the executive branch, the president says. I don't really even care what Congress says about that right now. They could try to change the laws, but it's got to go to the Supreme Court. And to tell the Supreme Court says the equal protection clause does not apply to undocumented children, it applies. So right now it applies, okay? Once again, I don't want to hear it. I don't make the law, man. Like this whole phrase about don't shoot the messenger. I get it. I'm the messenger. If I'm the first one to tell you this, well, you're welcome. Send me a thank you note, if you will. But don't get mad at me that this is the way the law works. This is the way the law works. Okay. You can tell I'm a little on edge because I'm tired of having these arguments where people want to argue with me about what they wish the law read. Go change the law and then get the Supreme Court to enforce it. If not, quiet mouse, because that's the law. Okay. So if you got voucher programs, pretty sure undocumented workers are going to get it. And if the law in your state is written where undocumented workers cannot get it, I think that's going to be challenged. I think it's not going to happen. I think taxpayers are still going to pay for those kids to get vouchers right now as it stands now. Okay. Let's keep going. All right. I hope this is fun. I'm getting a little fired up as we go. Hopefully not too boring. So 2002 was like the next pivotal case around vouchers constitutionality. And this is Zelman, Zelman versus Simons Harris. Okay. This is out of Cleveland. And Cleveland's voucher program let parents use public funds at public, private secular, or private religious schools. And most vouchers were used at religious schools. And challenges claimed an establishment clause violation, which was, okay, the premise is we're supposed to keep church and state separate. We're supposed to keep religion out of schools, all those things. And well, look, there's been a lot of adjustments in the law since the founding of our country, okay? And I'm not going to dig deep into this religious versus education, whether or not it's allowed or not allowed. Just know that vouchers at this point in 2002 were being used, and it was mainly to send the voucher money to religious schools. And somebody students said, this is a violation of religious crossing over into states' rights, right? I mean, into our laws, right? And we're supposed to keep church and state separate. Well, the court said there's no violation. So they can have their vouchers go to religious schools, and that's a problem. And that's not a problem. That's fine. And the program was considered neutral with respect to religion, and the aid reached religious schools only through independent parental choice. Okay, so this is because the parents chose to do it, and they could choose a private school that had religious connections or didn't. But it was up to the parent to make that decision. And because we in America are America, we are the government in the United States, which is, don't get me wrong, trust me, in North Korea, the people are not the government. The government is the government, and the people are in opposition, okay? In a lot of socialist countries that say, but in America, we are the government. And so we, as the government, choose to make our kid go to a religious school with a voucher. The court said, that's all right. That's just choice. So it gets a little confusing, doesn't it? It's like you're allowed choice, but you're not allowed. Okay. Anyway, so we can have all these different choices, and parents can make a choice. So you can have vouchers go towards more religious schools. If that happens, that's not going to be a violation according to the federal government. All right. So hopefully you're starting to, if you got a little checkbox on what's allowed, what's not allowed, vouchers can be used to go to religious schools. Check. Vouchers can be used by undocumented children. Pretty sure. Check. Vouchers can be used to segment blacks and whites. No, X, no, can't do that. Okay, so I think we're kind of getting a framework for what we want to do here. All right. So 30. I'm writing a little timestamp down right now. Sorry. Okay. So let's fast forward to 2017, just right around the corner, just a few years back, right? Andrew F. versus Douglas County School District. And in this case, the parents of a child with autism, so now we're getting into like Americans with Disabilities Act and disabilities, and how, whether or not we're going to segment those out or protect them, right? Because remember, we said we're going to protect race, we're going to protect documentation, but we're not going to protect wealth and income disparities. Okay, so that's not protected. Okay, so now we're going to get into this about a child with autism. And in this case, the child with autism argued that his IEP under the IDA, which is disability law, guaranteed more than minimal progress. Guaranteed more than minimal progress. I don't know what minimal progress means, but apparently the individual education plan for the student was very basic, and it really didn't help get them promoted. It didn't help get them moving along. It was really minimal at a point. So kind of think about it that way. Now, the holding. An IEP must be reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. Let me break that down. You've got to have basically a program for children in need that are appropriate for them. So if it can be more aggressive to get them going, it's got to be more aggressive. But if they're way, way on the spectrum and they have very limited abilities to function, that plan can be limited. So there is some flex. It's not one plan fits all. And I think that, actually didn't dig into this in case, but I would guess right now they probably had very similar IE plans for everybody with autism, even though autism is a spectrum. Some are much more capable than others in more and more need, right? So the plan should flex and adjust based on the student, not kind of a cookie cutter plan, right? So that's what the court came out and said. And so this was a more demanding standard, reasonably calculated, was a more demanding standard than merely more than a de minimis standard. So this matters. Let me kind of simplify this again if I can, is that the IDEA sets a meaningful floor for special education progress in public schools, and families that are using private placement may experience different IDEA entitlements unless state law or program rules restore them. So if your child has disability or have at-need issues, I don't know what's going to happen with the voucher programs. I don't know if they're going to be the same rules that are going to require all those schools that take vouchers to increase the independent educational plans for these students. We don't know that right now. And so they could be different unless there's a specific state law that says all children, regardless of race, regardless of religion, regardless of documentation, and regardless of wealth, and regardless of ability, have to receive the same education. If your state constitution doesn't say that, the federal government kind of like, well, we'd like you to do a little bit better, but we can't tell you what vouchers are going to do yet. Okay, so I don't know about disability right now. Okay. Let me cover a few more cases in this one, and then I'll see whether or not I can kind of summarize where we are right now. All right. So, let me jump to I want to do this right. So hopefully don't fast forward. I'm going to cover two more cases right now. Espinoza versus Montana Department of Revenue, right? They did the Department of Revenue on this one, right? Because they got all the money, right? This is a 2020 case. And in this case, a state tax credit scholarship barred scholarships to be used at religious schools under a state no aid clause. Now, once again, we're back to religious schools. Okay, and they're saying they give a tax credit. Tax credit is a type of voucher. Okay, so tax credit, voucher, grant, whatever. Okay, they're slightly different forms, so just think about them kind of the same. It makes it simpler for me anyway. The holding was that once a state subsidized private education, it cannot disqualify schools because they are religious, which basically goes back to support our earlier case dealing with religion, which was the Zellman versus Simon Harris, right? And so they basically said, no, if you're going to give a scholarship, you're going to give a voucher, you don't get to pick the kind of school they pick. Now, there is going to be some weird stuff going on, like in Florida, I'm hearing this, where the people are getting vouchers, but they're not using it for education. Like they want to go to Disney World and call it like a field trip, or they want to get a trampoline and call it the gym class. Little funny anecdotes that are probably not too funny. But that's really not for education, right? That's not a choice. That's a type of way you're using the money. But if you give people the choice to have a voucher, they can pick the school choice of their desires. That's the free exercise clause. So states generally cannot exclude religious schools from generally available private education benefits based on religious status. So forget about it, right? All right. So let's do Carson versus Macon in 2022. M-A-K-I-N, Macon. So this was in Maine. And Maine's tuition program for towns without public high schools. They didn't have public high schools. Okay. Public tuition program for towns without public high schools allowed private schools only if non-sectarian. Once again, this religious argument. So they could be no religious. The state argued it excluded, would not allow religious schools to get that tuition program, aka a voucher, if they had anything religious tied to them. Now, the holding was that the use status distinction did not save the exclusion. So denying otherwise available public benefits because they would be used for religious instruction also violates the free exercise clause. So we've been very consistent that we're going to allow vouchers to be used for religious schools. That's the one thing that in this talk, I hope I made clear, right? So if you've got a voucher program that excludes religious schools, you know that it's going to be kicked, right? So just be aware of that, and don't let a state legislator, not be aware of that ruling also. So give them a little help. All right. So what these rules mean for vouchers, like put simply, right, is there's no federal right to equalize funding. That's the Rodriguez case. Now we do have guardrails on what are allowed. This Brown Plyler law, Andrew, which is public systems must ensure racial equality, open access for undocumented children, and meaningful language access. and real progress for students with disabilities. So we've got to do all that. And then religion and vouchers is the federal test favors neutral parent-directed choice. Okay, so the bottom line is that the modern federal rule book says that vouchers can exclude, the modern federal rule book says vouchers can include religious schools if it's parent-driven. But public school civil rights duties are heavier than with most private schools if they're getting state money, right? Federal money. Okay, so I think what I'm going to do is I'm going to break because this is thick stuff. And I'm going to start to get into what these rules mean for vouchers in different states on part 2. Thanks for watching.